Joining us now to talk about the future of the Supreme Court and other big cases coming up in 2014 is Jordan Sekulow, the Executive Director of the American Center for Law and Justice. How are you, Jordan?
I'm good. Thanks for having me, Doc.
You as well. Thanks for being here. Happy New Year. What are the biggest cases coming up Supreme Court for 2014?
Sure. Well, opinion-wise, we're going to have some opinions in some huge cases. First of all, in the case involving campaign finance limits, again, whether or not the limits on aggregate, so how much money you can donate total to different federal candidates, are those limits legal or do they violate the First Amendment? We're also going to get an opinion on legislative prayer. This is a town council in New York, the Greece case, town of Greece, whether or not they get the same standard as our state legislatures do, which is means that if they want to have prayer, they can, and if people are offended by it, well, that doesn't matter. In America, you get offended. So that's cases that we're going to definitely get opinions on.
Are those ones that we already
had? As for oral arguments,
those ones we already had the oral arguments on. Is that right?
Right. The oral arguments have happened. Also on the recess appointments case, the NLRB, we actually represent Speaker Boehner there. The National Labor Relations Board right now is effectively not working because President Obama said, well, I had the power to make these appointments, even though the Senate wasn't actually in recess. Now, it will be interesting to see whether or not this latest move by the U.S. Senate, which affects everything but Supreme Court nominees, the nuclear option that was invoked. If President Obama wanted to moot this case out, he could just try to rush through these nominees very quickly. So that could happen. As for upcoming cases for oral argument, I'd say, the biggest would probably be the legal challenges to the HHS mandate. I mean, you've got, which is part of Obamacare, the contraceptive challenge, two of those, which are going to be very important before the court because it's what many of us said when Obamacare passes, even the first legal challenge to the Affordable Care Act was just the beginning of the legal issues within this law.
Well, that's going to be legal issues for the next 200 years, isn't it? I mean, we're going to be battling Obamacare for hundreds of... That's an interesting thing. Every so often, after a long period of time and multiple challenges, you will see issues die down. But more often than not, Jordan, we see these things just keep getting challenged by whatever side it is trying to come up with some different answer or some different solution.
Well, and this is one of those cases which is really in light of what we told people, all along. You talked about, it's a 2,700-page law that was codified to 850 pages. And really all that was doing was giving power over to the executive branch, to these, what we call administrative authority, to really write the law. And that's where we get the HHS mandate case. If you read through the Affordable Care Act, you won't find contraception coverage mandated. It was what was interpreted by Health and Human Services. So that's just the beginning again. As you said, these cases, even if this law survives somehow with all the changes that keep happening day to day, the legal challenges that it faces are not over with. In the Obama administration, these are the challenges I want to make clear to people. For private businesses, not religious organizations, but private businesses. And the Obama administration has been mostly losing in court, and they were unwilling to give up. So they're fighting it all the way to the Supreme Court.
Yeah, it's really interesting, though. I think we lost over the years the idea that we have to fight this stuff. A lot of us got soft. We're sitting on our couch watching TV. This stuff never stops. And anytime you stop battling these nuts, the progressives out there, they are going to run roughshod over you. We now, in some ways, have to play catch up.
That's right. I mean, you think about the fact that we have a case that we'll get an opinion on where legislative prayer, I mean, it's going to be on the line, could be held unconstitutional at a town council, even though in the 1980s the Supreme Court said it's absolutely fine to have a chaplain paid for by a state. It was Nebraska, just like Congress has a chaplain, and that chaplain can come from one denomination. It doesn't have to be a chaplain that represents every faith. But now we've got a challenge to, can a town do the same thing? And by the way, if a town can't, will that affect what a state and federal government can do? Every time these cases go back before a new Supreme Court, which this would be since, we're almost 30 years, or we are 30 years since the last time they looked at legislative prayer, you could, again, lose that right. I mean, we're talking about a court which has been very 5-4 lately and expect it to be on these cases that are upcoming.
All I know is we better make sure that people like Anthony Scalia, that they are protected. I'm serious. People need to follow him around with pillows, wrap him in bubble wrap, throw salt on the sidewalk. We don't need him slipping or falling. I mean, that's all that has to happen. One small thing like that, Jordan, the whole thing could be lost.
Yeah, and people sometimes forget, there's always speculation in Washington, who's going to retire, will there be retirements, the court is aging, and that's true. And so far, there's been not really a shift. President Obama did not appoint anyone that really shifted the balance. But the question will be will the president get a chance to sway the court? He's still got a couple more years. And will the Senate possibly invoke the nuclear option? There's nothing holding them back, by the way, that says, in their latest move, they said it won't apply to Supreme Court nominees. But if you accept what they've done as okay, which the Congress has, the Senate has, then they can do that for Supreme Court nominees. And the other one we'll want to look at is, do any of the liberal justices retire before the 2014 election so they could get someone in their place before possibly the Democrats lose control of the Senate, which more and more people are predicting as days go on.
Okay, so the big Obamacare one coming up has to do with the contraceptive. That's the one. What's coming
That's
after
right.
that?
The challenge to HHS, the HHS cases, there's two different HHS cases. There's also a big abortion case the court is considering taking, which is the Arizona 20-week abortion ban. So there's the cases that have already been argued that we'll get opinions on, the cases that will be argued that we'll get opinions on later this year, upcoming year. And then there's also the court will take into consideration cases to hear in the late spring or early fall. One of those is Arizona's, one of the more restrictive abortion bans in the country at stopping abortion after 20 weeks.
Yeah, it's the usual suspects coming up again, over and over again.
Yeah, Planned Parenthood.
Yeah, there it is. They keep fighting. A friend of mine, Jamie Radke, who ran for Senate in Virginia, I heard her say one time something really interesting. She said, the Constitution was the compromise. So for those of us that believe in the Constitution, each and every day we get up and say, that's where our center is. That's what we do. So anything that happens out there from the progressives, they're challenging that every day. We're just trying to stay right here, right with the Constitution, the compromise from 200 years ago. They challenge it every day.
Every day they want to rewrite what the words mean. You can amend. There's a reason why there's an amendments provision within the article, Article 5. It tells you how you can change the Constitution. There's multiple ways to do so. It doesn't say you can change it based off society changing, so judges then interpret it, or justices get to interpret words differently. And that's the liberal versus conservative view. The conservative who says, wait, this was written a certain way, and it can be changed. And it has been. There's 27 amendments, and you can go through that process, and that's a way to correct what you may want to or make clear what is not clear. But what the left has done is said, well, instead of that long process, we'll just come up with a right to privacy and say that's what abortion is, and we'll cover that there. We will expand the idea of Article 1, Section 8 to mean that a state can't do anything with border control or enforcement because naturalization is only the federal government's rules. And so they will use it both ways. And conservatives, which is interesting, it's why it's much tougher to predict, I think, when it comes down to the Supreme Court. Conservatives look at each case, and we may not always agree with a conservative justice or a justice that leans more right, but they look at each case and they take it on its own. The liberal judges or justices of the Supreme Court, it's a lot easier to predict. It's much more clear where they're going to go because they don't care about precedent. They don't really care about
it's all just emotion.
The Constitution.
Yeah, it's all just emotion. It's just
politics.
react. All right, Jordan Sekulow, thanks so much for joining us, buddy. I really appreciate it.